Hello, this is the workers' compensation primer or overview on workers' compensation law in Florida. Good day. Today I'm going to talk a little bit about workers' compensation law in Florida. If you're injured on the job in an accident in Florida, you will come into contact with the workers' compensation system. Since 1935, the state of Florida has had a workers' compensation law that provides limited indemnity and medical benefits to people who are hurt on the job. If you have an accident, the most important thing to do in the beginning stage is to make sure your employer knows that you have been hurt on the job. You have to tell the boss, I've been hurt in an accident on the job and I need medical attention. Under Florida law, this notice to the employer must occur within 30 days. So don't have an accident and go home and think you're going to sleep it off and not tell the employer about it. You have to tell the employer because the employer has the obligation to let his workers' compensation insurance carrier know about your accident and need for medical attention. Generally, when you're hurt on the job, the workers' compensation insurer will authorize care with a occupational medical treatment facility. These people see a lot of people with many different injuries and try to evaluate what kind of medical attention is necessary. You cannot pick and choose your own doctor to go and see for your medical care. That care is controlled by the workers' compensation carrier. The doctors at the Occupational Medical Center will decide what your diagnosis is and what kind of treatment plan is necessary. They will determine whether or not you have work restrictions, whether or not you're able to return to full duty work, or whether or not you have light duty work restrictions, which means you cannot lift more than X amount of pounds, you can't stand for a period of time, you can't crawl, bend, do all kinds of things that you used to could do before you were injured. So, you go to the doctor, he will give you a document that will tell you what your work restrictions are and what your status is. You take that, if he says no work, then you don't go back to work, you go home and you try to recuperate. Once the insurance carrier is notified that you're unable to work, they're supposed to provide you limited benefits which total up to approximately 66 2/3 of your average weekly wage. So if you make $100 a week before you get hurt, workers' comp will pay you $66 a week when the doctor says you can't work. The doctor will provide a treatment plan. You'll go to physical therapy, you'll take medications, and hopefully you will get better. Usually the conservative care is nothing, and they'll see you back in 2 weeks, and if you're fine, they return you back to work. But if you continue to complain of pain, which is what you must do if you have pain, you got to complain to the doctor, then you will be maintained under no work status. As the healing line goes on, you get better, and the doctor will maybe return you to a light duty job. Now, if you're a roofer, there aren't too many light duty jobs. If you're in construction, there aren't too many light duty jobs. If there's office work available, that will generally be construed as light duty work. So you go back to the light duty job if your employer has it. If your employer does not have it, then the workers' compensation carrier will continue to pay you. At some point in time, the doctor will decide, oh, you are complaining about this problem for so long, maybe we need to do surgery. Maybe we have to have an MRI test to determine whether or not you have herniated discs or torn muscles or meniscus or a rotator cuff or something like that, and you require surgery. If you require surgery, you're unable to work, and the workers' compensation carrier will pay for that. After the surgery, you'll go through physical therapy, and at some point in time, after all the treatment has been provided, the doctor will determine that you have reached something known as maximum medical improvement. That is a plateau where the doctor does not expect there is going to be any more improvement. At that point in time, you'll be entitled to something known as impairment benefits, where for every percentage of an impairment rating that the doctor assigns, you will be entitled to a number of weeks of benefits. The only other classification of benefits you'll be entitled to after that is called permanent total disability benefits. And permanent total disability benefits are only provided to people who cannot do a light duty job on an uninterrupted basis. So permanent total disability means there's no job in the workforce available for you to do, and the carrier will have to pay you up until the age of 75. So this is a brief overview of the workers' compensation system. It is a system designed to be self-executing. Supposedly you don't need a lawyer to help you with this system, but if the insurance carrier denies you indemnity benefits pay or denies you medical treatment, you may need to see an attorney to see what your rights are under Florida workers' compensation law. Thank you very much. Hope to see you soon. I hope this video helped you today, and if you're having any kind of legal questions that you'd like answered, please feel free to call us, and we'll be delighted to help you resolve your problem. Thank you.